Hello, my name is Jacob Fuqua. This is one part of four of the assignment 14 for the Instructional Leadership 564 course, Law and Ethics at Jacksonville State University. Specifically, I am going to talk about the Alabama Educators Code of Ethics and religion in public schools. Now, when the country was founded, we had the First Amendment, which grants citizens a lot of different rights and freedoms. One of those is the freedom of religion. The next thing is the 14th Amendment. That grants the rights and privileges of U.S. citizens. That basically establishes the ability to practice religion freely. Part of the First Amendment is the Establishment Clause, which states a state cannot create laws to aid a religion or show favor to one over another. That is according to Essex 2016, page 16. Educators, because we are public school officials and public school is funded by the government, we serve as government officials, especially in the school setting. Therefore, because we are government officials, we cannot promote a religion and we must remain neutral when discussing any and all religions. There's also a law of neutrality where educators must remain neutral in religious capacities, meaning that if there is something discussed about religion, we have to remain neutral. And that is according to Essex 2016, page 17. Now, what religion can and cannot be done within public schools? Religion can be taught in public schools as long as it is in the standards and it does not promote a single religion. Such as if you're talking about world history, part of the world history standards within Alabama are religions, but you look at all the religions. Religious texts, such as the Bible, can be taught in public schools as long as it is for the historical aspects within the text and not promoting the religion. So you can look at the different stories from a historical perspective. You can also look at them from a literary perspective, things like that. Within a school, all religious activities by students are permitted either before or after regular school hours or the regular school day. It must be student-led, and it must be on a voluntary basis. That's Essex 2016, page 37. We as teachers or educators cannot force a student to do something, okay? In addition to that, if we allow students to use the school for religious purposes before or after school, it must be open to all religions. You cannot prefer Christianity over Islam. It has to be a general basis that everybody has the ability to do that. A teacher or an educator cannot refuse to teach any curriculum based on their own personal religious beliefs. That is according to Essex 2016, page 45. Now, all that is simply is that somebody cannot refuse to teach something because they believe something else, meaning that a Christian has to teach evolution, regardless if they believe in evolution or creationism. Now, in terms of religious dress, teachers are allowed, they can wear religious dress, but it can be disallowed if that religious dress is used to promote or convert to a religion. Specifically, if a teacher wears a cross necklace and they're sitting there telling kids, hey, you should buy a cross necklace and become a Christian, okay, then you can't do that. That's where it draws the line. But if you're just wearing a cross necklace because that is your freedom of expression, then that is allowed to do. Now, students, okay? Contrary to what people think, students do have the same right as everybody else, including the freedom of religion. Students can discuss, promote, and engage in religious activities as long as no educator in the school has directed them to do so. An example of this would be like a prayer at the graduation ceremony, okay? If a school employee directs somebody to start a prayer at the graduation ceremony, that is unlawful, that is promoting a religion. However, if the students collectively as a class select somebody amongst their student body to give a speech and that student chooses to pray, then that is perfectly acceptable. Also, all religious activities must be voluntary and student-led or created. Okay, for say Fellowship of Christian Athletes, for example. All right, a teacher can be present when that is going on, but it has to be student-led. Okay, teachers are there to supervise only. We may not direct students in activities or promote any single religion. Okay, It all has to be student-led. Now, in addition to this, which this is kind of a hot topic, sort of, Pledge of Allegiance. In recent years, there's been numerous athletes from professional events and stuff that have volunteered not to stand for the national anthem and stuff like that. It's 100% up to them. Okay, the Pledge of Allegiance is a voluntary activity. The national anthem is a voluntary activity. Public schools cannot require students to participate for a lot of different reasons. One is because in the Pledge of Allegiance, it talks about one nation under God. Okay, a lot of people view that as promoting a religion. In addition, there are certain religions out there that by saying the Pledge of Allegiance, you are putting country over religion, which in their religion is not right. So therefore, the Pledge of Allegiance is strictly a voluntary activity, and schools cannot promote or force students to recite it. Now, here's another thing: holidays. Okay, most people think that religious holidays cannot be celebrated within public schools. Well, they are wrong. Okay, holidays can be celebrated within public schools, but they cannot promote a religion. Okay, holidays have to be viewed from a neutral standpoint. Okay, they can be celebrated as a Christmas party. Okay, but you cannot sit there and watch a play over the birth of Jesus Christ. Okay, you can have Christmas trees up, you can have different holiday parties, but they have to be from a secular, worldly manner. Okay, because it reflects the joy and merriment of a holiday. That is according to Essex 2016, page 36. So all holidays have to be from a neutral standpoint. They cannot promote a religion if you are doing that. Okay, most schools will sit there and have a Christmas party, or they'll just say a holiday party. Okay, as long as it is not promoting a religion, then holiday celebrations are okay. All right. So Alabama Educators Code of Ethics. Okay, the state of Alabama issued a code of ethics that educators have to follow. Basically, they have to follow it to maintain good ethical behavior and to make sure that they are providing students with an environment where they can learn. In total, there are 9 standards of ethics that educators must follow. Failure to follow these ethics can result in suspension, revocation, or denial of any and all educational certificates. Meaning, if you violate one of these ethics, you can be suspended, your certificate can be suspended, therefore you lose your job. Your certificate can be revoked, meaning that you no longer have a certificate, you lose your job. And a pending certificate can be denied, and therefore you will not get a job. You will not be allowed to teach in Alabama public schools. It is also the duty of an educator, according to the Code of Ethics, to report to their principal, superintendent, and the Alabama State Department of Education anyone suspected of violating any of the standards within the Code of Ethics. Now, that is strictly to make sure that we are checking and balancing our fellow educators, that we're making sure that they are following the Code of Ethics just like we are following the Code of Ethics. Now, for these Code of Ethics, I am just going to go through here and tell you what each one talks about, and then towards the end, we're going to talk about some other stuff. The first standard was a professional conduct. An educator should demonstrate conduct that follows generally recognized professional standards. In other words, just be professional. Okay. Trustworthiness. An educator should exemplify honesty and integrity in the course of their professional practice, meaning that you need to be honest, you need to have integrity in what you're doing. Unlawful acts. An educator should abide by federal, state, and local laws and statutes. Just because you are an educator does not mean that you're above the law and that you can do things that other people can't. Okay? You still have to follow the laws just like a regular citizen. Teacher-student relationships. An educator should always maintain professional relationships with all students both in and outside the classroom. We are educators first. We are adults. The people, or the children, students that we teach are children. Okay? We have to maintain a professional relationship with them at all times. Number 5 is alcohol, drug, and tobacco use or possession. An educator should refrain from the use of alcohol and or tobacco during the course of their professional practice and should never use illegal or unauthorized drugs. Again, in other words, just follow the law. Okay? You should refrain from using alcohol. You should refrain from using tobacco. Okay? Even though that educators are old enough in most states to do that, to use those things. Okay? We still should refrain from using them, especially within a school setting. And definitely do not use illegal or unauthorized drugs. That will get you fired very quickly. Public funds and property. An educator entrusted with public funds and property should honor that trust with a high level of honesty, accuracy, and responsibility. In other words, such as principals, assistant principals, superintendents, people that are using public funds, people that have access to public funds, okay? It is your job to be honest with it, to accurately report those numbers, and you have the responsibility to do that, okay? You don't want to be caught embezzling or anything like that because, one, it's wrong, two, it's unethical, and three, you're taking away from the kids, which is the main reason that educators are in school, is to give back to the students. And 7, remunerative conduct. An educator should maintain integrity with all students, colleagues, parents, patrons, or businesses when accepting gifts, gratitudes, favors, and additional compensations. Okay, meaning that you shouldn't take money from a student's parents to give them a better grade. Okay, you should have integrity with that. Okay, if you are given a gift, it should be because you are given a gift. There should not be anything else attached with it. Maintenance of confidentiality. An educator should comply with state and federal laws and local school board policies relating to confidentiality of students and personnel records, standardized test material, and other information covered by confidentiality agreements. Okay, as educators, we have access to a lot of information. That information you can almost deem as classified. Okay, if your eyes as an educator see that information, it's for your eyes only. All right. It's not to be shared with the public. It's not to go talk to little Susie down the road and say, hey, I saw where you did this, this, this in class. Okay, that's none of our business. Okay, that's none of their business. If it is confidential, it should remain confidential. Number 9, the abandonment of contract. Okay, an educator should fulfill all the terms and obligations detailed in the contract with the local board of education or educational agency for the duration of that contract. In other words, if you are on contract for a year and you have to work from beginning of August to the end of May, okay, that is your contract. If you have to abandon that contract at any point, or you just decide that you don't want to work anymore and in the middle of March you stop showing up, okay, that is unethical. All right, you sign a contract, you need to finish what you started. Now, for each of these 9 standards of ethics, within the Alabama Code of Ethics, there are both ethical practices and unethical practices that each one of these lists. I did not go in detail as to put them on here. You can research them on your own if you want more information about it. But within the Alabama Educators Code of Ethics, there are ethical practices and unethical practices that are listed that you can look into if you would like. Okay, the references. The Alabama State Department of Education, the state website for education. If you go there and go into the search, you just put Alabama Educator Code of Ethics, it'll be the first thing that pops up. It'll be a PDF document, and it'll detail all the information that I just gave you. The other one is School Law in Public Schools, which is a practical guide for educational leaders. It is written by Essex from 2016, is the 6th edition. Okay, that is where the information I got on religion in public schools. Okay, for religion in public schools, basically you just need to maintain a neutral view. Okay, you need to make sure that you are not violating the Establishment Clause, that you are not establishing a religion, and you need to make sure that you maintain neutrality amongst any religious conversations, and then you should be good. And as anything religion involving students, as long as it's student-led and it's not directed by a school official, then it is okay to do. Now, I know that there are 3 other parts that you will be looking at within this overall video. I hope this was very informational for you. And if you have any questions on the very first slide, see if I can go back to it. If you have any questions, my email is up there along also with the instructor. If you have any questions about the Alabama Educators Code of Ethics or religion in public schools. So thank you. I hope you all have a great day.
Hello, my name is Terry Dokes. This is for Instructional Leadership 564 Ethics and Law with Dr. William A. Kaiser. Today I'm going to be talking about liability in student records first, and then moving on to students with disabilities. Student records. The primary purpose of maintaining educational records should be to aid school personnel in developing the best educational program for each student enrolled in the school. Public Law 93-380, the Family Educational Rights and Privacy Act, or FERPA, protects confidentiality of student records. It guarantees parents and students certain degrees of confidentiality and fundamental fairness with respect to the maintenance and use of student records. FERPA's main objective is to keep students' information private and not released or shared without parent consent. A school district can release some directory information on students only if such information is published yearly in a published newspaper of some sort, and as well, parents can object to this as well. Under the FERPA law, parents do have rights, teachers have rights, as well as students have rights. Parents at any time can inspect their child's records with a school official present to interpret the information that's held within the file. They can challenge the accuracy of information that is there, and they can deny consent of those records being released. When consent becomes necessary to release student records, it must be provided in written form and signed and dated. So school personnel also has some rights under the FERPA as it relates to student records. Teacher rights or school personnel must have an educational interest in that student, which is considered a qualified privilege. Teachers, must sign in and out of those files as well. So an educational interest or qualified privilege could be that the student is in your classroom, you teach the student in some kind of intervention, maybe the student simply goes to lunch with your block. Also, as it regards to school personnel, school counselors and nurses fall under that qualified privilege as well. It is to be noted that school counselors are not required to share information they learn from students with parents. Counselor records, they do not fall under FERPA. So students' rights are about the same as parents. Once they reach the age of 18 or they enroll in some kind of secondary institution, then they can request those files. They can also challenge the accuracy of things that are in those files as well. So what happens when you violate the FERPA laws? Well, you can face charges of being libel, slander, and defamation, just to name a few. So now I'm going to move on and talk to you about individuals with disabilities as in regards to education. So the ultimate goal of educators, should be to ensure that every child learns within his or her capabilities. The IDEA, Individuals with Disabilities Education Act, was passed by Congress to define clearly the responsibilities of school districts regarding children with disabilities and to provide a measure of financial support to assist states in meeting those obligations. So the term children with disabilities is defined by IDEA as those who meet some of these conditions, but not all. mental retardation, hearing and speech impairments, visual impairments, any other type of learning disabilities, brain injuries, orthopedic impairments, autism, just to name a few. In 2004, it was amended. It was amended to include that eligible children with disabilities between the ages of 3 and 21 or up until graduation receive a free appropriate public education, or FAPE, consistent with their individual needs. Also within the IDEA, it establishes substantive and procedural due process rights. Each state must formulate a policy that ensures certain due process rights for all children with disabilities. It requires each state to allocate funds. To the fullest extent possible, children with disabilities must be educated with children who are not disabled. Regular classroom teachers should identify students who may need educational services after that teacher has had some time to work with the student, and then they would submit a formal request. It is noted that ELL or ESL students should carefully be screened when being referred to special education services due to the fact that their limited language proficiency could be their interference. So once that student has been identified, the next process is to intervene. So we call it response to intervention. It's used to provide early effective assistance and support to children who are experiencing some kind of difficulty in learning. RTI minimizes academic failure based on that early intervention. Response to intervention is followed through a multi-tiered system of support. Your tier 1 is going to reach your average students with core instruction. Your tier 2 is going to be those targeted students, and you're going to provide them with that targeted intervention. And then your tier 3 students are going to be your students that need intense intervention. So once all of that has been taken into consideration and done, you are going to get with or collaborate with the student's IEP team, Individualized Education Plan team. That could consist of the student if appropriate, the parent, the regular education classroom teacher, a school system representative, others with knowledge of the student, a person who can interpret the results, and or a special education teacher. So here is a look at the IEP process. The teacher is going to identify, going to collect all that data, both formal and informal. Then after that is taken into consideration, that meeting is going to be held to develop what the child needs, what are their educational needs, where are they at currently in their learning ability, and then it is going to be decided and agreed upon some goals for the student to attain within the year, whatever services they may need, and where the student, if any other additional placements are needed. Students with an IEP are placed in a least restrictive environment. It is designed to ensure that students with disabilities will be provided the broadest range of opportunities based on a least restrictive environment. As you can see, the least restrictive environment would be in the general education classroom. If that is not appropriate for the student, then a special education classroom. Moving on to more of the most restrictive side, which is a special school, homebound, or some other kind of residential facility. Inclusion for students with disabilities. District must be properly prepared to meet the diverse needs of such students, which may be accomplished through systematic and continuous training, as well as appropriately developed policies and procedures regarding the teacher's role in relation to students with disabilities. So teachers are going to have students in their classroom with disabilities. In regards to disciplining students with disabilities, the first thing must be to recognize, was the behavior due to the student's disability? And if it was, then that student should already have a BIP, a behavioral intervention plan in place. Moving forward, an alternative, excuse me, I can get that out. Education setting for up to 10 days could be in place. Suspension for up to 10 days could be in place. And again, parents can appeal these discipline decisions. Maintenance of the IEP. IEP meetings are to be held annually. If changes to the IEP are necessary after the annual meeting for the school year, the parent and the LEA may agree to not convene to have an IEP meeting to make changes, but instead develop a written document to amend or modify the current IEP. IEP meetings are on a need basis as far as changing, making any changes to the student's IEP. And that is my presentation for those two topics of student rights and as well as students with disabilities. Thank you.
Hello, I am Shayla Finkley Petway, and I will be discussing with you today about understanding due process in education. What is due process, you may ask? It is constitutional protection against unfair deprivation of life, liberty, or property. It applies to public schools within the 14th Amendment. It ensures fundamental fairness for students and school personnel, and it is composed of four different aspects: procedural and substantive due process, vagueness, and presumption tests. Procedural due process guarantees that fair steps are taken before any action is made. It includes a notice of charges or proceedings. It also provides an opportunity to be heard. Level of due process depends on the seriousness of the deprivation. It protects against arbitrary actions by school officials such as myself or you. Substantive due process. It ensures valid reasons for deprivation of rights. It is only used if it is reasonable. Within schools, it protects students from arbitrary and capricious acts. Officials must have a compelling state objective. So when I say a compelling state objective, I am referring to anything in reference to health, safety, or the welfare of the faculty and staff within the school. It protects freedoms like speech, assembly, and religion. It guarantees that students' freedom or property cannot be taken without appropriate justification, without using the process or without using due process. Vagueness and presumption tests. A vagueness test, the rules must be clear, it's not guesswork. Presumption tests, officials need clear evidence before action. Examples is presumption of innocence in student discipline. One particular case study that we studied that happened in 1975 was Gauss versus Lopez. Well, Lopez was in a cafeteria with some other students, roughly about 75 students, and they were getting ready for assembly. They did not agree on who the speakers should be for that assembly. It became out of hand. It became where there was a disagreement between the student body and the school officials. Well, there was never an opportunity for Lopez to be heard. So the main issue in that case was that students were suspended without a hearing. The court ruling, even for short suspension, meaning less than or equal to 10 days, students need a notice of charges. They need an explanation of the evidence, and they need an opportunity to tell their side about what actually took place or what actually happened. Another case study took place with Galt in 1967. He made an obscene phone call, but the issue there was what would normally happen for an adult didn't happen for him because he was a juvenile. An adult could have made an obscene phone call and only paid $50 fine for that. So the issue in this case was there was a juvenile who faced harsher punishment than an adult. Court ruling: the juveniles deserve the same due process as adults. This is something to you that may seem as a given. You want everybody to be treated fairly. However, in this particular case, that was not the situation. The impact from this case: it defines school officials' response in disciplinary hearings. There are levels of due process. Short suspensions is less than or equal to 10 days. Rudimentary procedures, you get an immediate notice and a hearing possible. Longer suspensions or expulsions, there are more extensive procedures. So you need a notice, you need a hearing, you need legal counsel, witnesses, etc. You may ask yourself, why does this even matter? But as an educator, you want to make sure that your students are protected from unfair treatment. It ensures decisions are based on facts and not assumptions. You wouldn't want to be reprimanded by your administrator with just by them assuming something. You want them to have facts, and you want them to present those facts to you. And you want your students' rights to be upheld with dignity and respect. There are 4 key takeaways that I do want you to leave this meeting with. Is the due process about fundamental fairness and just treating people right. Level depends on the potential deprivation. Both procedure and substantive aspects matter, and clear policies and fair hearings are crucial. Clear policies are fair, and hearings are crucial. Keep that in mind, if nothing else, that there are steps to due process, and you want to follow those steps so that everyone involved is treated fairly. And if you were in any situation and you were accused of anything, you will want an opportunity to be heard. You will want them to know your side. Okay? Thank you all for listening. You have an amazing day. If you have not had an opportunity to read this literature, my information came from our textbook, which is called School Law and the Public Schools. It's a practical guide for educational leaders. So when you get the opportunity, if you have not, I encourage you to purchase the book and take the opportunity to read it. Thank you and have an amazing day.
Hey, my name is Emily Doty, and the first thing I'm going to be talking about is search and seizure laws in the educational setting. So this presentation is going to have an overview of search and seizure laws in the educational setting. We're going to look at legal boundaries and the implications. After this, I hope that you have a better understanding of how educators and administrators, what their rights are and their responsibilities are during search and seizure. The first thing we're going to talk about is the New Jersey v. TLO citation. It's listed here. This case made it where the Fourth Amendment does not mandate school officials to obtain a warrant or establish probable cause before searching a student under their authority. The constitutionality of the search is contingent upon 2 things. First of all, the search must have reasonable grounds, indicating that the evidence of a law or a school rule violation has been found. And the scope of the search must be related to its objectives, considering all the factors as the student's age, sex, and nature of the infraction. So you cannot, as a teacher, go and just search everyone's backpacks. You can't go through everyone's purses. You have to have reasonable grounds indicating that the law was broken or a school rule was broken before searching anything. And if you are searching people's bags, I hope that the reasonable grounds that you have established are enough that you find something, because it is a big deal for teachers to be going through people's things. The searching through people's personal items can have legal implementations if you are wrong. So let's keep looking at how these policies are established and what rights you have as a teacher. So the school policies that we're talking about, it's so important for clear and comprehensive search and seizure policies in educational institutions. If you do not know what your school's rules are on these, you need to ask, you need to find out, you need to read them, because they will be a little different in each school, especially varying on which age you're teaching. But the scope of a school search should consider the reason for the search, the age and sex, and the nature of the infraction. Searches should be restricted to a specific incident. They should not be conducted broadly across all students. So if you think, if you walk into a bathroom and you see smoke, you cannot broadly search everyone in the bathroom. You have to talk to the students and narrow it down and find out. And if you cannot narrow it down to a specific student that you are fairly certain, you don't get to just search everyone. So your best bet is to discuss it with the students and see if you can narrow it down, or just run them out of the bathroom and state that it is not okay to be smoking in the bathroom. According to our text, the Fourth Amendment protects all citizens against this unreasonable search and seizure. In searches involving educators, the legal standard ensures that the search is reasonable and consistent with your school's policies and guidelines. Students do have rights. They have constitutional rights that must be respected in the context of search and seizure. Educators do have more leeway in conducting searches within the school environment compared to like a police officer. Teachers are still bound by legal standards of reasonableness and respect. Law enforcement officials must adhere to constitutional standards even when in a school setting. Okay, so this is what I was just talking about, an unlawful broad search. Conducting a broad search targeting all students without a reasonable suspicion is unlawful. You have to have reasonable grounds for a search. You cannot just do a broad search. You can't be like, I think someone has something in their backpack. I want everyone to bring their bags and let me look through them. You cannot just do a broad search. In the case of smelling marijuana, that is something that we did in our school assignment. Smelling marijuana in the hallway, are you allowed to just search everyone? No, you cannot. It's unreasonable. It would lack specific suspicion, and that infringes upon students' rights. So as a teacher, you cannot just broad search because you have a suspicion. This presentation has given you an in-depth exploration of search and seizure laws in the educational setting. It is so important for educators and administrators to navigate these legal boundaries with professionalism and adherence to our constitutional rights of teachers and the students. It is essential to uphold the balance between maintaining a safe learning environment and respecting individual liberties. I'm going to list my references here at the end. These are what I referred to during the presentation. In this presentation, we're going to be talking about freedom of speech in public schools, understanding the boundaries that students have, and the powers that be that teachers may have in this situation. My name is Emily Doty, and I will begin. Speech and expression rights have been limited based on educational context, students' age, the writing nature, which would be, is it a school-based publication or is it a student-based publication? If it was student-based, did they use school equipment? So there's lots of factors that play into what speech and rights the students do have. Was it written on the school grounds or was it done outside of school? Regardless of these, students in the United States do possess freedom of speech and they do have rights of expression. These rights are not absolute and can be limited by the educational context. So let's discuss some of those limitations. To understand the freedom of expression, students have the right to speak, write, or express themselves without censorship or restraint. In the school setting, that is allowed as long as it does not interrupt education. So schools can set rules for safety and order so that someone's freedom of expression does not disrupt education and learning in the school. Administrators can review publications fairly, avoiding abuse to suppress content. Student journalists have limited rights in school-sponsored publications to maintain educational standards. So if it's school-sponsored, the school has all the rights to read through it and talk with the journalist and see if it's appropriate to be put out as a school publication. Now, educational institutions often face challenges in balancing this free expression, but also maintaining a respectful and inclusive environment. Censorship and self-censorship can hinder open dialogue and limit the students' ability to voice their opinion. So there has to be a balance. It has to be where the students have the freedom of speech. They can learn to argue their point, to give their opinion, but without using language that's not allowed, or without causing uprisings in the school, or without encouraging students to walk out of class or to stage a riot. There are peaceful ways to argue your opinion and to express that. Okay, context matters. Okay, context matters in all of these things we're talking about. So in this particular instance, the nature of the writing, we just talked about disruption of educational environment or infringing upon others' rights. You can't do that. So creating an environment that encourages respectful dialogue, active listening, all of these are important in the freedom of expression being allowed in the school system. It's important that they embrace diverse perspectives and have open communication that improves the educational experiences of these students. The school's rights. Schools have the right to create rules and policies that maintain the order, safety, and well-being of students. That is the most important job we have as educators, is to teach students how to have their opinion and express what they are wanting to say while maintaining order and safety and protecting the students' well-being. These policies may impose limitations on speech and expression within the school setting, but as educators, I feel like it's our job to work with students to show them how to express themselves in a positive way that does not cause issues in the school setting. Now, the students' rights. Students have the right to express views that don't disrupt school operations. Fairness in the review process is essential. Now, let's look at that review process. Okay, student journalists' rights are limited if in school sponsored publications. I read this in the Student Press Law Center on the website. The censorship upheld in a court case in Hazelwood School District v. Kohlmeyer for various reasons. The school administrators can review the school-funded publications within defined parameters, and that was in our textbook. The textbook says the parameters include reason, time frame, responsible parties, and specific material. Abuse of this process to suppress objectionable content is cautioned against. Now, as I talked about earlier, students may create a non-school sponsored newspaper, and they have more protection if it's produced off campus, not using school resources. Then they have more freedom of what they're allowed to put out. So in conclusion, upholding freedom of expression in an educational setting is vital for fostering student empowerment and civic participation. Understanding these complexities of freedom of speech in public schools is very important. Now, balancing these student rights with the school policies creates this conducive learning environment where students feel safe to journal and express opinions in a safe environment. These are the references for the court case I referenced and a reference in our textbook that I used. All right, thank you for your time.